Welcome back. Today I'm joined by our friend Mr. Jim Makowski, attorney at law. We're going to be talking about bail and why it's important to have an attorney present when this goes on. So, Jim, let's talk about this. You know, you've been questioned, the police have decided to make a case against you, and you go for an arraignment. Let's talk about that first. What is an arraignment so the people know what we're talking about?
An arraignment is the first reading of charges against a criminal defendant. The judge is going to read out the charges. They're going to ask the defendant if they understand what the charges are, and then they'll set future court dates. They'll also address the issue of bail. And it's incredibly important to have an attorney present at a bail hearing.
But look, Jim, here's the thing, do I understand the charges? Yeah, I'm charged with this, but I've seen lots of times people go without an attorney, and when they go, they want to, I don't want to say argue with the judge, but they want to plead their case. Is that not a good thing to do at that point? I mean, you've got the judge, and generally you're not going to have a prosecutor there, so...
Everything you say is being recorded, and everything you say can be used against you and will be used against you. At the bail hearing, the police are going to give a little bit of background about a defendant. It's important to have an attorney present to humanize the client. And what I mean by that is when a judge, say we have a lethal shooting situation, the judge is going to look at a number of factors to determine what bond should be set, if any. Danger to the community. If that defendant presents a danger to the community as a whole. Flight risk. The seriousness of the crime. Those are all factors that go into whether or not the judge is going to grant bail, and if so, how much and what conditions of the bail. If you have an attorney present, a retained attorney especially, the attorney will address those issues with the judge. For example, I've just been involved, or Terry has just been involved in a lethal self-defense shooting at his house. He's being charged with open murder. I'm going to address the judge, explain that Terry has been a resident of his community for 20 years, that he is a practicing attorney, that he's married with 2 children, that he has strong community ties, and explain to the judge that he is not a flight risk, that he's employed. And once all of those factors are explained to the judge is going to give a far lower bail bond than if he doesn't know that person at all.
So, that's interesting you mentioned that. But here's what I see a lot of times. I see, and you mentioned a retained attorney, I'm going to take it a step further. How about a retained criminal attorney? How many times have you seen someone who doesn't understand criminal procedure, an attorney I'm referring to, blow a arraignment and ladies and gentlemen, you have to understand, this is one of the simplest things in criminal procedure, what Jim is referring to. But how many times have you seen non-criminal attorneys come in and blow this?
People may have a friend who's an attorney who does probate work or does divorce work or does bankruptcy work, and in an emergency they call that person who's not a specialist in criminal defense, ask that person to come to court. That person may or may not know what they're doing, and the results will show through. It's ridiculous sometimes the things you see, but it can make a huge difference whether you're out on a $50,000 personal bond or remanded into custody until the case is over. And once a bond is set, it is difficult to get that bond lowered. It can be done, but you're going to be spending some time in jail.
Now you mentioned earlier about conditions of bond. Give me some examples of, things you can't do once you're on bond.
Quite often, especially in a self-defense situation, they're going to order you not to possess weapons, so you're going to have to get rid of your firearms, move them into someone else's safekeeping.
Does that mean I have to sell them, or?
No, just give them to a family member, a friend. Worst case scenario, get them to a dealer who is willing to hold them for a period of time. They're going to charge you for that, obviously, but get them out of your possession. Another typical bond condition is not leaving the state. Can be a problem for people who have to travel for work.
Now, is that something you might address during the arraignment process or the bond process?
Absolutely, you let the judge know that that your client has business ties to Illinois, Ohio, whatever state. They have a planned business trip, and you ask for permission from the judge right then to travel out of state. You're far more likely to get it if an attorney asks for it than if you ask for it yourself.
Okay, now, are the police, I mean, now you mentioned the police earlier. What are they going to say? I mean, do they get a say in your bond? How does that work?
Yeah, the police are going to have some say in the bond. They're going to make a recommendation, and the judge will follow that unless they have more information from an attorney or some other source of information. Well, what other source of information is there? The judge is going to follow whatever information that he has and make that recommendation. You need to give that judge good information to tell the judge that you're not a danger to others and that you're not a flight risk.
You know, one of the things I used to do is I would talk to the police beforehand, before we got in front of the judge, and I would say, hey, Mr. Police Officer, what kind of bond are you looking at? He would kind of give me a number, and I said, listen, can't we work this down? I'd kind of work on him or her for a bit.
Absolutely.
But again, that's something else an attorney can do for you in that point. So one other question, Jim, as this process goes on, so are you saying you should have an attorney literally from beginning to end, cradle to grave?
Absolutely. If you can get an attorney to the scene of a self-defense shooting before the police even leave, before the body's removed, great. Sometimes that's not possible. You certainly want that attorney there before you answer any questions, you or your family answer any questions.
Will that help towards bond as well, having your attorney present prior to, the police making statements and all those other wonderful things?
Showing up with a retained criminal defense attorney demonstrates to the judge that you are serious about your defense, that you're taking this matter seriously, that you're addressing the issue, and it's going to go a long way to reducing the bond. It can make a huge difference.
Outstanding. So, got some good tips here from an excellent criminal defense attorney. Jim, how can the people reach you?
You can reach me through my website, www.makowskilegal.com, MAKOWSKILEGAL.com, or call my office at area code 313-434-3900.
And there'll be a link in the description to reach Jim. And if you're ever in a situation, Jim might be one of the attorneys that comes out to help you. Again, as a member of Firearms Legal Protection, we have attorneys all across the country to handle the things that Jim's talking about. For more information on that, please go to our website, firearmslegal.com. And if you like the information you're getting here today, please hit the subscribe button.